And when you hear the term estate planning, I think there's a perception out there that you think that, oh, this is only for the wealthy, but you found in your years of doing this, that's not the case.
Sure. Well, and so people don't understand is that the state of Iowa gives us all a default estate plan. There's a default estate plan contained in the Iowa Probate Code, Chapter 633 of the Iowa Code. If you're bored, I know you're not.
Fantastic. I'll go look that up.
That's my job, not your job. Yes. I get it. But it details very specifically exactly where your assets are going to go. And what I think a lot of people don't recognize, especially if they're on a subsequent relationship, especially if they're a blended family, or if they're in a situation where all of their kids don't need to be treated equally, whether it's a special needs situation or you've provided more support to one of your children than you have of the others and you need to equalize on the back end, the Iowa Code doesn't take any of that into play. So having an actual set of documents that outline all of your wishes, all of your desires, is truly the only way to ensure that it's really going to go the way that you want it to go.
Yeah, so most people watching have some form of an estate.
Everybody does, yep. Whether or not you recognize that, whether or not it's necessarily what we call a plannable estate, chances are you have family heirlooms or personal property you want to go to certain people, or the family home, checking account, savings account, retirement accounts. I mean, everybody has all of these things, or some of these things, I should say, collected, and that's part of where the puzzle piece comes in. Is every single one has different pieces that fit together in a different way, and it's my job, after talking to Loren about it, after talking to whoever, and obviously the client, right there, that's very important, to then put all those pieces together in the way that makes the most sense for their family.
Yeah, so everybody has an estate, but I think a lot of people confuse what an estate plan is. Sure. A lot of times when I talk to people about their estate planning, their legacy plan, I say, what have you put in place from a legacy planning standpoint? And they say, well, I have a will. Mm-hmm. And a lot of people have a will that's outdated, but they have a will nonetheless, and they think that that is their plan. A will is a legal document. It is a part of an estate plan, yep, but it's not necessarily a plan. And there's a lot of other things that can come into play, like what's the difference between a last will and a living will? Yep. And do you need to have a last will and a living? There's a lot of different things that need to come into play that you need to have conversations with somebody who specializes in estate planning on the legal side to make sure that you have all the documents in place and your wishes will be fulfilled.
Exactly.
Yeah. And that leads me into, the will I think people are familiar with, but then you hear the term trust. Again, a term I think that gets maybe associated with maybe the ultra wealthy. Or
sure.
I couldn't possibly need a trust for whatever reason, but you find, Charlie, that sometimes a trust, a lot of people need a trust for various reasons.
Mm-hmm. I actually write more trusts than I write wills at this stage of my career. That wasn't maybe always true, but at the end of the day, what a lot of people don't understand about Iowa's legal system is, in order to move property from point A to point B, from you to your kids, from you to your grandkids, from you to your neighbor's cousin, whatever, it either needs to A, have a beneficiary on it, and it transfers automatically, so things like retirement accounts, IRAs, 401ks, bank accounts, brokerage accounts, all those things can have beneficiaries on them. Or it has to go through a process called probate. And probate is the judicial process, essentially, where your assets are marshaled, and then there is, via some judicial intervention, via a judge issuing orders oftentimes, your assets are then distributed to your beneficiaries. The problem is, probate, especially in our state, can get prohibitively expensive. Probate can range, I generally estimate about 3% of your assets are going to get chewed up in probate. That range is technically 2% to about 4%. Obviously 3% is right in the middle, and that's easier for most people to conceptualize. Every situation is different. But generally speaking, if you think that about 3% of your assets are going to get chewed up, and what people don't recognize is that's the gross assets, it's not the net. So if you have a $350,000 home, and you have a $300,000 mortgage, it's not a $50,000 asset. It's a $350,000 asset for terms of costs. Well, you can really, really quickly, okay, I have a $350,000 home or a $300,000 home. I have, $200,000-$300,000 in retirement accounts. Well, now you're talking $500,000-$600,000. We haven't talked about bank accounts. We haven't talked about cars. We haven't talked about toys. We haven't talked about personal property. So let's say you're at $600,000, right? What's 3% of $600,000? It's $18,000. If you spend $18,000 on a trust, you have a very, very complex situation. So a lot of times, at least my process, is I like to educate my clients on, hey, here are kind of your options as it pertains to estate planning. And a lot of my clients do choose to go with a trust or a set of trusts, depending on the scenario, because the cost of probate in our state can be so prohibitively expensive that they just don't want to incur those fees, or more importantly, they don't want their kids to have to incur those fees. And potentially, lessen their inheritance and lessen their legacy, right? What they're trying to get to.
And that's one of the things that I like about what you do, Charlie, as far as your process, is it is a very educational process, right? You talk to the families and say, here's an option, here's the good, here's the bad, here's what it'll do, here's another option, here's the good, here's the bad, here's what it's going to do for you. And it's very state specific. So we're here in Iowa. State of Iowa has, in my opinion, some really goofy estate planning laws from a standpoint where if your probatable estate is north of 50,000, now that estate has to hire an attorney. And also that means that these other beneficiary type of assets, like your IRA, your 401k plan that has a beneficiary, can't get caught up in that in the expense of the probatable estate.
I didn't even mention that.
And a lot of people don't realize that. Is that something that you want to highlight?
Yeah,
a little
absolutely.
bit?
So when I talk about the gross assets of the estate, it's called the gross taxable estate. That includes everything that you owned the moment you passed away, and any taxable gift that you made recently. So if you just recently gifted somebody $50,000 because you're helping with whatever tuition, expenses, whatever that is, that's includable. You have a $3 million IRA and it goes to your kids via beneficiary designation. That we can skip that for court costs. There's a new law that went into effect this year that lets us skip that for court costs. But potentially on the fee side, it can be very, very expensive. And as an individual who's licensed in both Iowa and Minnesota, I can completely attest that our laws are just different. Yep. They come from a very different spot. They get to a very different stage, and it just is. And a lot of people like to fight against it, but it just is. And you need to have that information, and then make the decision based on what makes the most sense.
And just to be crystal clear, yes or no question, if I set up a trust, I can bypass paying a lot of these fees. That's why we're kind of spending so much time talking about these fees. You
can, yes. It takes some planning involved, but yes, you ask for a yes or no answer, I'll say yes.
Okay.
Yeah, a trust is a document, and there are a lot of people who set up a trust and then never use it or don't use it the right way.
Don't fund it, whatever that is.
So you have to make sure the trust is just a document, then you have to understand how to use it within your overall legacy plan. Thank you for watching this clip of Retiring Today, and don't forget to subscribe. If you have questions about your retirement plan, take advantage of the complimentary 15-minute retirement checkup phone call.